Very good morning, students. Namaste. I'm Dr. Shruti. Today we will going to discuss about the standing orders or the we call it as the Industrial Employment Act 1946. So in this act there is no uniformity when there was no uniformity in the conditions of the service and the workers until this act was brought into the light. The frequent causes of the friction between the management and the workers is the industrial working in India were mainly due to the absence of the clear-cut employment conditions known to the workers. This is why the Labour Investigation Committee 1944 to 1946 observed as an industrial worker has the right to know the terms and conditions which he is expected to follow, and the consensus of the opinion in the favor of the separate central law, making it obligatory on the part of the employer in the country to frame and enforce with the approval of the government defining the employment condition. So that's why this particular act has been formed. Now, what are the objectives of this particular act? To minimize the industrial conflict first. Second one is to foster the harmonious relations between the employer and the employees. The third one is to require the workers to define the conditions of the workers. Next one is scope and applicability. Now, this act is applied in the whole of the India as it is applies to the every industrial establishment wherein 100 or the more workmen are employed or were employed on any of the day preceding to the 12 months. या 12 महीने पहले वो आए उस organization या उस factory में काम करने. The next one is we talk about the act not apply to the certain industrial establishment. Where this act will not be applicable, we're not going to discuss about that as well. To which to which the provisions of the Chapter 7, the Bombay Industrial Relations 1940-74, or the Madhya Pradesh Industrial Employment Act Standing Orders 1961 are applicable. In those uh, 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 in those establishments where the Bombay Industrial Relation Act and Madhya Pradesh Industrial Employment Act has been established, there this law will not be applicable. Now, what are the definitions of the standing orders? There are so many definitions are there. First one is certifying officer. It means a labor commissioner who is appointed by the appropriate government for the purpose of certifying the SO, that is standing orders. Appellate authority, the it refers to any authority which is appointed by the government for the purpose of seeing to the provided by the employer or any of the work. Now the third one is the standing orders. The rule of the pertaining the working of the establishment is to submit by the employer. Now, what is the procedure, certification, modification, and appeal of the this particular SO, or we call as a standing orders? Within the 6 months of the date of which the act is applicable to the industrial establishment, the employer of the industrial relations in industrial establishment is to required to submit the certifying officer. Now, the 5 copies of the draft standing orders proposed by the adopted by him in his industrial establishment, together with the prescribed particulars of form number 1 of the workmen employed and name of the trade union in any of which they belong to. Now, second one is when the receipt of the draft, the certifying officer shall forward a copy thereof to the trade union if any of the workmen or the workmen of the requiring the objections. Right? If there is any objection occurred by the trade union or the workmen, then the objection copy will be there. And which of the workmen may desire to make the draft standing orders to by submit by him within 15 days from the receipt of the notice. So the certifying officer shall decide whether or not any modification or the addition to the draft is necessary to render the certifiable under the act, which shall make an order in the writing. The certifying officer shall thereupon certify the draft standing orders and shall send within 7 days of copies of the certified standing orders to employer with the trade union and the representative of the workmen. So this is what the procedure and the certification of the S. Now the next one is to appeal. Any employer, workman, trade union, aggrieved party by the order of the certifying officer may may within the 30 days of the appeal to the appellate authority, whose decision will be final according to section number 6. The appellate authority shall within the 7 days of the order shall send the copies to the certifying officer to the employer and to the trade union. Copies of the standing orders are as certified by it, the authenticated to the prescribed manner. So this is what the procedure of appealing. Now, uh, I think this is all for the day. I hope you understood this particular video, and I know it was quite long to understand this thing. So we will have this session in a live class as well. There is no worry, right? So we'll have this in the standing orders in the live session as well. This is a very important topic. So please try to make the make the notes. If you cannot able to do so, please let me know. I'll definitely try to help you out in that particular case. So thank. Have a great day.